welcome. It's past, so I'll get started. So my name's Charlotte Walsh. I'm a lecturer in law at the University of Leicester, and I'm giving the first talk, and I'm also chairing the next two panels, so throughout the morning, on law, politics, and society. So I teach in a law school, and my specialism is in challenging the prohibitive drug laws from a human rights-based perspective. And I've been doing that for quite a long time. And it's often seemed like one of those things that seems, idealistic and there's a sort of niche group who will argue for these rights, but that it's not going to kind of fly in the real world. And I think that's maybe unduly pessimistic and sort of hopefully convince you of that through my talk. So one of the things that gave me sort of reason to celebrate was when I read this. So this is a quote from a publication that came out in 2015 by the All-Party Parliamentary Group on Drug Policy Reform. And this is a group, they're all parliamentarians, so they have a certain amount of power, but what the group say, there's no kind of requirement that be translated into law by any means. But it was the first time that I've ever seen a sort of cohesive group of parliamentarians say that actually the drug laws are problematic on human rights grounds. And so that's a really significant shift, I think. And so this quote from them, and they're basically saying that we should use Article 8 of the European Convention on Human Rights to challenge the drug laws, specifically in relation to possession or purchase or sort of home-scale cultivation, on the basis that it criminalising this conflicts with our own rights and that those activities don't interfere with other people's rights. So that's their kind of basic rationale. And one of the sort of curtailments of, or perceived curtailments of developments in drug policy is the fact that most countries in the world are signatories to the UN Drug Convention. So this idea that we're limited in what we can do domestically because we're signed up to this international system of prohibition. And they looked at that issue in this paper, and they said, we have our obligations under the drug conventions, but we also have human rights obligations, and that actually they should take precedence. If the two come into conflict, then our human rights obligations should take precedence, which again I think is interesting. So one of the things I think, and this was kind of flagged up by the response to this publication, one of the things that I think is a barrier that we need to overcome here is the idea that what we're talking about is trivial. So this idea that, you're kind of arguing for your right to take drugs and it's kind of trivial. So this kind of encapsulates that. This was the response from the Express, taking drugs is a human right, MPs say, and junkies could use Euro laws to avoid jail. So I think that's the kind of take on this that we want to sort of avoid. And I think, really getting to the heart of this isn't about, the right to take drugs. It's about our right to freedom and the extent to which the state should be able to impinge upon our personal freedoms. That's what's at stake here, regardless of whether or not you're interested in taking drugs. That's what we're actually concerned with here. So just a little bit of kind of backdrop as regards why I think the human rights perspective is such a useful one to adopt. So first of all, that human rights are universal. They apply to all of us equally. So that's a good place to start. And also this idea that they're normative. So in other words, they express a view of the world that those people who adhere to them, the way that those people who adhere to them believe that the world should be. This is like an idealistic vision of what we think that the world should look like. And then we can use them as a tool. We can kind of look at what we're doing as a society and see whether or not we match up to these normative standards. And that's not just optional. The fact that we should scrutinise what we're doing. That's the law in this country. We're signed up to the European Convention on Human Rights. It's embodied domestically through the Human Rights Act 1998. And that means that the courts have a duty to make sure that all legislation is in accordance with human rights law and the way in which it's being applied, both when we're bringing new legislation in and people can challenge old legislation in the court. So that's the situation that we're in. I also think that human rights are really important because you only need one person to change the law. You know, one person has to convince the courts that there's a problem. It doesn't automatically change the law. What the courts will do is they can make a declaration of incompatibility, and then Parliament have to kind of revisit that. So we have parliamentary sovereignty in this country, but it's a big driver towards that if the courts are saying, you know, the law is out of line with the European Convention. So because of that, and I think particularly if we're kind of honing in on psychedelics, like, don't be fooled by your surroundings, it's a minority pursuit. And so you're unlikely to get a sort of mass social movement pushing for change when it comes to psychedelics. And so that's why I think human rights can be useful for that reason. And I just think it's a useful tool for activists in terms of it gives us a language, it gives us a way of framing the problem. And this idea of sort of deploying human rights as a tool for social transformation, so a sort of like protest variant of human rights. So we have had attempts to challenge the drug laws through human rights in this country before, and they've tended, not exclusively, but they've tended to focus upon Article 9 and the right to religious freedom. And those cases in this country have been unsuccessful. So, you know, in some countries there are exemptions for religious grounds for use of some substances. It's not the case in this country. Any attempt for that to become the case have failed. And so the reason I want to look at Article 8 rather than Article 9 is so that we're on kind of fresh legal ground, in a sense. And also just because it's broader. You know, even if we win in terms of Article 9 and right to religious freedom, it will normally be a win for a specific religious group, whereas this is more all-encompassing, more in the kind of spirit of things, I think. So the other element of Article 9, it protects freedom of religion, but it also protects freedom of thought. And I've spent quite a lot of time over the years arguing from this perspective, arguing for our cognitive liberty, which I still, you know, vehemently believe that the drug laws transgress. And I'm going to be looking at cognitive liberty at the end in a kind of really interesting case that's coming through on that. But I think sometimes, you know, following on from the recommendation from that report we looked at the outset was using privacy, and that's maybe more palatable to people. You know, this idea that we should have a right to privacy is maybe a better framing than a right to freedom of thought. It might be more kind of have more mainstream appeal. And obviously, you know, there's overlap. Like, what we have the freedom to think is highly related to who we have the privacy to become. You know, these two things, they're artificial distinctions in a sense. So it's just a question of how you're kind of framing your claim. Okay, so looking at Article 8 and how we might use this to challenge the drug laws. So you can see here that Article 8 is the right to privacy. And privacy has been construed very broadly. So you've got the kind of the external dimension to privacy, you know, the kind of the space around you, but also the internal dimension to privacy. And this idea that we should be left so that we're free to self-create, you know, to create our own identity. And so I think this is really kind of pivotal when we're looking at psychedelics, because they can be so fundamental to people's development of their identity and development of their existence in the world in a meaningful way. And so I think it really kind of fits here. And it brings in some sort of really interesting issues when we start to think about identity and we start to think about Article 8. And one of there are these sort of differences in terms of what it means to be left free to discover our own identity. So the essentialist perspective is this idea that we kind of have an innate identity, we have an innate self, and that we need to be given space so that we can sort of excavate down to that, like find out who we truly are. But then some people say, well, that's actually really limiting. It's sort of saying, well, this is who you are. You just kind of have to discover who that is. And then the existentialist perspective is that we need to be given the freedom to self-create so we can become who we want to be. So it's more a sort of a moving towards rather than a sort of digging down. And maybe, you know, on the face of it, that second one fits really well with psychedelics if we sort of conceive of them as a transformative tool, that it links in with this existentialist take on it. But I think, you know, there's a paradox here in a sense that also with the psychedelics, you know, for many people the experience can be that when we use them, we sort of free ourselves, you know, in technical terms from the default mode network, or, you know, more conversationally, just from the kind of the grooves that our mind typically treads. And then that once we get beyond that, once we get beyond the sense of being a particular ego in a given point in space-time, that we reach this inner space that actually feels like our truth, this kind of boundlessness, this inner peace. And it's this idea of you kind of find the self by losing the self. And that takes us back to the sort of the essentialist perspective. I guess it depends which self you're looking for, like your sort of your small self or your big self, and also both, as is normally the case when you're faced with kind of a choice in this kind of situation. Both are probably true. You know, we're kind of sort of simultaneously unearthing ourselves while kind of creating our own avatar to exist out in the world. So, you know, it's complicated, but whichever one, both, we need the space in order to be able to do that. And the famous quote from Whitman, "I contain multitudes." So obviously we all have multiple selves, and you know, we sort of display different ones at different points in time with different people. And I think that's really revealed by the psychedelic experience, where again you can have this sort of paradox where you feel like you don't exist, but you sort of simultaneously embody the entire cosmos. So I think it's really interesting when you're thinking about theories on identity, and also thinking about them in relation to psychedelics. And also I think, again, so that this issue doesn't get trivialized, just kind of highlighting the fact that this isn't some kind of solipsistic endeavor. You know, we need to discover who we are so that we can work out our values, so that we can know how to exist in the world. So this idea of we turn inwards, and then that we can then turn outwards and bring what we discover inwards out into the world. And, you know, many people who are involved in taking psychedelics of whatever description would conceive of themselves as being on this deep philosophical, spiritual quest, you know, trying to work out what does it mean to be human, what's the best way to live in the world. And so that's why I think a sort of a test case in this area is so important. So just looking briefly at our prohibitive drug laws that I argue kind of get in the way of this process. So we've got two main pieces of drug legislation in this country. And I've just put up here in relation to them their stated aims, what they say that they're for, because I think there's been a really alarming development in British drug policy very recently. So the 1971 Act, the Misuse of Drugs Act, the main piece of drug legislation that we're all used to in this country, its stated aims are about the control of drugs that are capable of having harmful effects. So it's rooted in harm. So from a sort of, you know, liberal position, that's what we expect the criminal law to be about. We're trying to prevent harm to others. That's why we have criminal laws, ostensibly. And so in terms of its stated aims, the Misuse of Drugs Act is unproblematic. It's highly problematic in terms of how it's deployed, but at least there's at least a kind of facade of it being a liberal piece of legislation. Whereas the Psychoactive Substances Act, which came in last year, talks about controlling substances that have a psychoactive effect, and there's no reference made to consequences. It just says that when you ingest them, it affects your mental functioning or emotional state. There's no reference to any impact on anybody else other than yourself. So it doesn't really get much more private than your own mental functioning or emotional state. So I think this is like a you know, a kind of clear transgression of Article 8. So just looking at Article 8 in a little bit more detail. So obviously Article 8 isn't an absolute. Some of the rights are absolute. Article 8 isn't an absolute right. You know, sometimes our rights will bump up against other people's rights. And so there's qualifiers to Article 8. I've laid them out there. And normally when it comes to, so the right might be engaged, but then they'll say, yes, but by your doing that, you're doing something like, for example, leading into disorder or crime in the country, or it's a threat to health, etc. So there'll be these kind of consequentialist reasons why you're not allowed to express that right to its fullest capacity. I mean, I'm particularly interested in psychedelics, and this is obviously a psychedelic conference. When you look at the qualifiers, it's quite hard to make that case in relation to most of the psychedelics that there is a big risk of them transgressing other people's rights. That there is, they're not highly correlated with crime. They're not highly correlated with health issues in the way that some other substances might be. And I mean, not to overstate this, I'm not saying that there are no potential risks to other people or no potential risks to society at large. Of course there are, but you need to, I think, sort of contextualize that for it to make any sense. Most of us, when we kind of look round at one another on an unkind day, would probably think that most of us lead lives that are questionable, sort of maybe in terms of what we're doing to ourselves physically, emotionally, spiritual, or not doing to ourselves, so you have to kind of think that there needs to be necessary limits on what we're trying to do with the law, and that certainly when you're talking about the criminal law, it's a very blunt tool, and you should only really be bringing that into play where there are significant risks of the qualifiers kicking in, particularly when there's a protected right at stake. So we're not saying there's no problems, but we might be saying we could deal with those problems through education or through benefit maximisation. We could deal with them in a less problematic way, as indeed we claim to do through with alcohol, with cigarettes, etc. Arguably not terribly well. The problem is with the rights in practice. What's happened with the previous cases is that we have the qualifiers to the rights, and then they're engaged in this very, very sort of cursory way. So the courts, rather than carrying out, what they should be carrying out is a sort of evidence-based balancing act. Do the risks outweigh the benefits for society when somebody takes this? What we actually see in practice is that courts will say, drugs are illegal, therefore we assume that means that drugs are linked with crime, and so therefore it's fine to breach your human rights. So this really circular argument, it's a complete transgression of their obligations. Everybody who's challenging the law, the criminal law, what they're doing is illegal, or they wouldn't need to be, do you know what I mean? They wouldn't need to be challenging the criminal law. So it's just a circular argument to say it's wrong because it's illegal. They're meant to be testing whether or not it's justifiable that it's illegal, and that kind of doesn't seem to go on in practice. And you end up with this situation where human rights basically eat themselves. We're saying we'll only respect your human rights if you're exercising your autonomy in a way that we deem to be acceptable. And then they become meaningless. This idea that they're basically just languaged into existence. We can make them mean whatever we want to make them mean. And problematically, you've got similar vested interests often sort of imbued in who are creating the criminal laws and who is deciding whether or not human rights have been breached. It's all sort of power structures, different ones. Admittedly, we have separation of powers in this country, but they're certainly not sort of entirely distinct in terms of the interests that are being protected. I think another thing that's worth kind of pointing out here is when you look at the qualifiers, they set up this really unhelpful dichotomy. They're basically saying, we're looking at whether or not the individual should have this right or whether or not that unjustifiably transgresses the rights of society, as though those two things are separate. And it's nonsense. We all know that, and the psychedelics certainly kind of bring that into sharp focus. Society is made up of individuals. Society benefits from having enlightened, self-realized individuals. And so this idea that it's kind of one being played off against the other, this sort of competitive approach to rights is it's misleading, I think. And so I think... I actually think, I mean, you can sort of look at this in different ways, but maybe it's that's the problem. Maybe there is this recognition that if these substances were allowed and were kind of used more broadly, that perhaps that would lead to changes in society, and those who are invested in society as it is, don't want those changes. You know, you can kind of look at it in that way. I really like this quote from Eisenstein. I'm going to read it, saying that, in fact, the prohibitionists are correct. The legalization of cannabis, LSD, MDMA, psilocybin, mushrooms, ayahuasca, and the other psychedelics would indeed mean the end of society as we know it. The threat that conservative political forces have identified is real. If these were just innocuous bourgeois playthings, experiences that one could consume on weekends to make life as usual a little more tolerable, then the guardians of the status quo would have little reason to prohibit them. They recognise, if only unconsciously, the revolutionary social and political potential these substances carry. Psychedelics can bestow expanded consciousness, perceptions and ways of being that are incompatible with those that undergird our society. And so, you know, you can have different views on that, but maybe that is the reason, rather than a sort of a threat to society in the way that it's normally kind of put forward. So lots of people kind of say, well, if everything that I've been saying is true, then it's actually naive to expect this to change through the courts. You know, if the problem is systemic, we're not going to change it through the same systems that brought the problem into play. So that really what we need is activism as against kind of legal formalism. And this idea, which, you know, I'm strong supporter of, that maybe we don't need to wait for change from above, we don't need to wait for permission, and people are just acting as if they're allowed to do this. I mean, that's always been the case, but I think it's kind of being amped up maybe with new technologies. So we have, I mean, the Silk Road is no longer up, but we have all kinds of drug markets on the dark web, obviously, where people are just buying and selling psychedelics as though that were acceptable, kind of beyond the purview of the law to a large extent, certainly not entirely. And then other examples, so for example, you know, ceremonies across the UK, and further afield, so we've got the cannabis clubs in Spain, which are, you know, slightly different, where this is sort of exploiting legal loopholes, and then interestingly, that's now increasingly being formalised. You know, it's kind of gaining legal recognition. So I think that's an important point, is you can start with something that is sort of subversive, and then it starts to gain legal traction and recognition, and then it becomes formalized. So that, you know, that process can happen. A similar kind of thing happened in regards to recreational cannabis in the US. You know, a lot of the people who are involved in the booming cannabis industry there were involved in the underground cannabis industry. And so I think it's interesting to look at, we don't need to choose, you know, activism or legal formalism. You can have all of this kind of going on at once. And just the other thing is that not to give up on the courts. So there's been a couple of cases recently that have been really, really heartening for me. So just looking at those. So first of all, many of you may have heard that towards the end of last year, there was a decision made in Mexico that kind of home use and home cultivation of cannabis was unconstitutional. So they're obviously, you know, they're not in Europe, they're not signatories to the European Convention, but they've got similar privacy provisions within their constitution. And if you read it, there's an English translation of it on Scribd. Is that how you say it? If you Google it, you'll find it, and it's great to read. You know, so they're basically arguing that they need the right to self-create, the right that these drugs are part of them forming their identity, and this is accepted by the court. It's accepted by the Supreme Court, and it's a first in the sense that it's not a therapeutic exemption, it's not a religious exemption. It's just that this is, I mean, it's not a first, but it's getting us out of those kind of like reified, you know, constructs that we can sometimes fall into. And the court said, you know, like cannabis can cause harm, but the criminal law isn't the way of dealing with that harm. We should use education and so on. So they took this kind of less intrusive approach. And then there was a similar case, again, I really recommend reading it. It's the case of Prince, which happened in South Africa in March of this year. And Prince, again, argued on the basis of privacy that he should have the right to grow and smoke cannabis in the privacy of his own home. Again, on privacy grounds, not religious or therapeutic. And the judgment is such an uplifting read. You know, when you read it, and this is the words of the judge that you're reading, and it feels like reading the words of activists. You know, they're talking about not only that this is a right that we're unjustifiably transgressing, but they're also talking about, you know, the racialized history of drug prohibition and how deeply problematic that is. So honestly, I thoroughly recommend reading it. It's you almost can't believe it's real. You almost can't believe it's happening. And so I think those two cases are, you know, they both happened in sort of relatively quick succession, and as I say, really heartening. And then there's a case going through the courts this summer. They're known as the Dagger couple. They call it cannabis Dagger in South Africa. And this couple had their home raided, and so they're challenging the cannabis law in South Africa. So we've just seen that they've already said that for kind of private use and home growing, that the Supreme Court has said that that's unconstitutional. But they're saying it's kind of broader than that, that the prohibition on cannabis itself is unconstitutional. So they want to kind of broaden out this. And they contacted me, actually. They'd been pulling together their defense, and they kind of Googled and they found some videos I'd done where I was talking about cognitive liberty, and they got in touch with me and they said, we're going to kind of bring that in as one of the main planks as our defense, because we think that's, you know, a great argument to bring in. And that's being heard this summer. So that would be amazing, you know, if they win, and also if they win on the grounds of cognitive liberty. I mean, how cool would that be? So so fingers crossed. So looking forward to seeing what's happening there. So I guess on a final note, you know, a note of optimism. You know, things can change. Things are changing, and so I think we're moving away from this idea that if you're, you know, I've heard it a few times over the course of this conference that, you know, we've got the idealistic hippies who argue from a rights-based perspective. Well, you know, it's working, so don't give up on that. And also, I think, you know, sometimes I find it a little bit embarrassing telling people that I work in a law school, because, you know, lawyers get a really bad rap, and I sort of think I like it when you can see the law being used as a tool for positive change. You know, we can sometimes use the law to overcome systems of oppression, and we can sometimes use the law as an empowering tool, you know, so that we can reach our full potential in this life. And I think, you know, sometimes it's really nice to be reminded of that. So thank you.